What are these applicable? What
My
is
lord, it is the matters between husband and wife. Husband filed an application for transfer of that case. Wife is employed in Canada in a bank. So in the transfer petition, Hon'ble Supreme Court called both parties made efforts and very lengthy efforts and who found that she is also employed. Husband.
Oh, is it the case where that costs for traveling?
Exactly same. Actually, my lord said that cannot be indirectly. My lord cannot be interpreted. We have paid that amount. Case is going on in the trial court. I'm informed.
So you question only that. So your writ petition has to go.
Please, my lord, and that was connected.
What is their writ petition?
Their writ petition.
My application claiming interim maintenance was rejected, and court has granted me traveling expenses.
That now they are going to pay that.
They have already paid me.
So your petition also has to go.
No.
Why you are earning so much? Why you want interim maintenance?
Sorry, it's not easy like what the opponent has said.
No, I read the order on the last.
Yes, my lord has read. My lords, I made an application seeking interim maintenance of rupees 1,50,000. My client is a graduate of MBA in political science. The husband is a doctor, MBBS, community medicine. MD in community medicine. I made an application for maintenance which was declined by the family court. And however, the court has ordered only for traveling expense. Agreed by that order, to that extent order, that is grant of traveling expense, the husband has preferred a writ petition.
Me to grant family court's order. What the family court has,
yes, my lords. Before take my lords to the finding, I just place two things. Family court declined maintenance on two grounds. I have suppressed the material facts. And second thing is that I have got sufficient income. Court has not dealt with the income of the husband. Just it has gone with the income of the wife. This is how the family court dealt with that.
What is the income of the wife?
Yes. She failed to disclose either alienation of any immovable property standing in her name or acquisition of any property in her name. When this court directed her to submit her taxpayer information summary TDS, she is compelled to disclose the acquisition and alienation of immovable property at Mumbai. It is pertinent to note here that her TIS for assessment year 2023 discloses that she sold the security and units of mutual funds of rupees 10,45,424. She purchased two immovable property. Kindly mark this, two immovable properties. This is factually incorrect. For total consideration amount rupees 2 crores 7 lakhs 99 lakhs 741. This is also factually incorrect. And for sum of rupees 1 crore 8 lakhs 82,141. And another property for sum of rupees 99 lakhs 17,600. This is also factually incorrect. The TIS for assessment year 2023-24 shows that she sold the property for sum of rupees 56 lakhs 33,139. All these information gathered from her TIS clearly shows that she purchased the more than 2 crores and sold the property of rupees 56 lakhs 33,130. 2 crores is factually incorrect. Kindly mark. Next, no doubt that she has produced some family agreement, registered gift deed, etc. But all the same are subsequent to commencement of litigation. Kindly, this is also factually incorrect. Family agreement is before the litigation. Gift deed was subsequent. Therefore, at this stage of the proceedings, that too, while considering the present application, in my opinion, those gift deeds, family settlement deeds cannot be considered. If the said documents were much prior to commencement of litigation, before the marriage of the petitioner, respondent, then the matter would have been different. But the thing remained as it is that respondent during the year 2021-22 purchased the two properties for consideration amount of rupees 2 crore, and for the year 2023 she sold the property for more than 56 lakhs. These materials have been suppressed by the best reason known to her. This is the finding. Next, admittedly their marriage was solemnized on 5/12/2020, but interestingly she shown her as a single in her income tax return filed for tax year 2020 and 2021 before the Revenue Agency of Canada. It is relevant to note here that in 2021 she filed her income tax returns for the tax year 2020. 2022 she filed income tax returns for the tax year 2021. But in both the said income tax returns she shown her marital status as single. Even though at the time of filing said returns she was married. Of course this is irrelevant, but however the court has noted it. But however, while filing income tax return for the tax year 2022 and 2023, for the first time she has shown her marital status married. But at this stage, apparently on the face of the record, it's clear that she gave false information about the marital status before the Canada Revenue Agency. The said fact is, though not much relevant for deciding the present application, but it shows that she has a habit of suppressing true facts. Pertinent to note here that respondent is claiming 5 lakhs towards the cost of litigation, alleging she spent the huge amount for.
Her statement of assessment liability.
Yes, sir. Yes.
Come to her expenditure.
Yes, ma'am. So I have stated that this is the cost, man. It's 1 crore, 1,40,000.
No, in that 20,000 has to be deducted because they are paying for your air travel.
Traveling the effective.
Medical expenses. heritage
It's only
service,
effective.
10,000.
They are paying.
Grocery and laundry charges as per month 15,000.
Yes.
Electricity 10,000. Miscellaneous expenses
Yes.
3,000. Legal expenses 20,000.
Yes. My lords, I'll for
If your expenses are 1,20,000, how much every month? How much you're earning?
I'm not earning anything. I left the job, everything, because I was in IC Bank. I got resigned. I left the job. Now the family court holds that I have suppressed the material. I got to purchase 2 property. All are factually incorrect. That is the reason why I placed their documents on record.
Why you are saying that you will not get a job?
My parents are staying in Bombay. I should attend the court proceedings and all. Then it's very difficult to travel.
You have a flight.
There is always there, but
husband is paying the.
because of the shock, which yes,
It is like something. Which
yes, my lords is right. Yes, exactly, my lords. Now, because of the petition filed by the husband, I was shocked and got it resigned. I am not able to work because of the mental
When is the
pressure.
marriage?
My lords, marriage takes place on 2020.
Hmm.
My lords, wife worked in India for a period from April 2020 to 2021. Then wife works in bank from April 2021 to July 2022.
What is the salary at that point?
Yes, 25,000, my lords, is the salary.
When they were separated?
Yes, sir. Separation was on 5/7/2021. Divorce petition on 2/7/2021.
From 2021 till now, she's not working.
Not working. Family court refers to income tax returns. This is the tax returns. Purchase of immovable property 2 crore 7,99,741. Then purchase of securities. These are the details called out. This is how the court inferred that there are 2 properties. That is, one property is 1 crore and odd, and the second is 99 lakhs. There's a family settlement. What had happened was that my father, he was having a property. He sold that particular property and he intend to purchase new property. So for that purpose, he's a senior citizen. He could not get loan at that point because of COVID period. He could not secure loan. The family agreement dated 13/4/2021. The divorce petition was filed on 27/2021. The family court says that this is a document which was done subsequent to the petition. It's factually incorrect. My lords, a family agreement which was entered between the father and daughter. First party is committed to personally repaying all loan installment monthly until its full repayment. Proceeds from the selling present flat of first party and ancestral property will be transferred to the bank account of second party for the payment of purchase amount of new flat in so and so. Another part of the payment will be done either through bank of either parties depending on the convenience considering the current COVID circumstances. Because of these arrangements, since the father could not secure the loan, my lords, this is the reason why, my lords, the property was purchased. Now, family court holds that it is a 2 property which is factually incorrect. Submission is concerned. Have a look at the gift deed also. Pursuant, this gift deed is 13/9/2020. That is after filing the petition. That is gift deed.
Why the
Correct.
gift deed is executed in favor
Because
of-
the loan was taken in my name. The liability to repay was with the father.
It's on the father. Correct.
Yes. So
Why
it is
it
my
transferred
duty to.
the daughter?
Yes. Yes, friends.
Why it is transferred to the other daughter then? If you look at the gift deed, it is given to the other daughter.
No. She's a mother.
Mother.
Yes.
Hmm.
Yes. I'm sorry.
Earlier in that agreement, when then it appears that she's residing in Canada due to COVID and all is mentioned.
Yeah.
She's not mother, I think.
Who?
Come to that sale deed.
Which sale deed? Family agreement. madam?
Family agreement.
Yes.
Come to that.
Yes.
Page number.
First daughter, she's not a party. The second daughter is the present petitioner.
You are saying that this gift deed is executed in favor of the mother.
Yes.
But from this, it appears that it is not mother, but it is elder sister. Which property number gift deed is made? The very same property.
Very same, only one property.
What about this 15, 16 lakhs, the amount that is lying in that bank account?
Yes. The whatever the amount which the sale consideration from that first property was transferred loan of rupees 15 lakhs 77,553.
No, if her salary is 25,000 per month,
Correct.
where is this 9 lakh 45,000? And she, according to you, she worked for 2 months,
It's 2 years, 2020 in the 22.
for 2 years.
Yes.
Hmm.
Of rupees
Her
50.
income should be per year, how much?
Please, my lord.
It would be 3 lakhs.
Yes.
What is this 9 lakh 45,365? Statement by the respondent
Correct.
shows that
Correct.
in the year 2020 to 2022, she had salary income
Correct.
increase 9 lakh 45,365.
Correct. Out of salary income of rupees 9,45,365, 5 lakhs 43,172 is from the salary which is gained from the bank.
How she will get that much salary?
For 1 year, 4 lakhs is the salary.
It should be 3 lakhs if it is 25,000.
I can produce salary slip also. There's no issues.
So, and understand that one property,
Yes.
the court had referred to 2 properties.
2 properties.
That is
That's
not
one
2
thing.
properties,
That's
it is
one.
one property.
Yes.
And the property is purchased by the foreign.
Correct.
She has only, because she only facilitated to obtain the loan.
Yes. Then my
Her income per month is 25,000.
correct. My
Matter. After the Honorable Court's observation other day, the deposited she has come for cross-examination. But every cross-examination has about 15 to 20 times cross-examination has happened. Now it has gone for, again they sought cross-examination. We are cross-examining. They are taking time. And there is in fact a direction by the Supreme Court for a speedy disposal. Now it's we have deposited the amount. She has come for some dates. Several dates she was absent again. And because of the absence, case could not go. And after some cross-examination, again, they seek time, matter is going on. One subject, petitioner being a permanent resident of Canada, was habituated of that lifestyle. Marriage was just to spoil the life of the respondent. Initially, it was claimed that she was love singer. It is illegal. It was her own decision to move out. Immediately after reaching to Mumbai, she applied for the job ICS bank, resignation from organization on 9 to 2021, where she was working with the respondent. She had joined the job on so and so. Number of respondents was also kept in dark about the location of the new flat worth rupees 2 crores purchased by her and her family. The respondent came to know about the address when she filed a complaint at so and so, my lord. Now these documents, there is an agreement between the father, they are released, etc. Everything comes later. Nothing was there. According to
Before the Supreme Court, why it should be?
No. Thereafter, this matter went on for a long time. It was Supreme Court spent a lot of time and even appointed one of the Honorable High Court judges, my lord. It went on several months, I am informed, my lords. And my lord, this document, my lords, that the alleged family agreement is a set-up document that is now produced later in the family court, which is disputed by us, my lords. This set up clean the stamp paper. We don't want to reveal everything, my lords, on the face of it. Stamp paper when it's there, the date when it's there, because all these are now the questions before the.
It's a registered document.
The family document is not registered. In the stamp paper, they have prepared it, my lords. Subsequent,
It's not a registered document.
no, not a registered document.
For what purpose you want to rely on the Supreme Court judgment?
Supreme Court. This order dated 13/10/2022 is evident that the petitioner may be working in Canada, as she stated that she wound up her work in Canada and she is now living in India. They agreed to take assistance to the marriage council. Justice was appointed as a mediator. The report has been received from the mediator stating that despite spending about 50 hours in different sessions, the parties and family members could not arrive at a family so and settlement paid as per so and so. Several meetings were held with the parties, though the petitioner was in Canada, and she attended the meetings through video conference. Petitioner is a permanent resident of Canada. She had shifted there in the year 2014, was working there on a well-paid job. Came to India for the matrimonial alliance. She is presently based in Maharashtra with her parents, stated to be working. No child. As far as the respondent is concerned, he is a doctor by profession. His divorce petition has been filed. So and so. Middle portion, my lords. Mediation report dated 8/2/23. Petitioner was in Canada throughout the mediation process. Attend the mediation there. There is one child born out of the marriage. Both the parties are well educated, engaged in their own jobs and professions. Present condition, the finance condition, the parties, the finance condition of the company. We do not find any ground issuing direction to the respondent to pay the expense of the petition in traveling, my lords. Then still she feels like then seeking reimbursement of expenses, my lords. She will be at liberty to file application before the court concerned. So
They have lived together for 40 days.
That's all, my lords. After the matter was transferred to Lordship mechanism, all steps are taken, my lord, to defeat the process of the court, to delay the proceedings, even though continuously being delayed, despite the specific order is there for this Honorable Court to expedite the process, my lords. 10th February 2024, order was passed. Thereafterwards, my lords, of course, the Honorable Court in that case, my lords, provided for 8,000. And then, my lords, 8,000, we had our objection because she's never coming. She's continuously dragging on the proceedings, my lords. Then we came up before this Hon'ble court. So since then, it's only because my lord directed that this petition also be tagged with this. It is tagged. Now, my lord, the trial judge considers everything as far as they raise up a defense now, my lords. This is not my income, I have resigned, etc. And that the amount of crores has not come from me, father has contributed, etc. These are all, my lord, the defenses which have been subsequently set up, my lords. It's not at all, there's absolutely no truth in all these defenses. Now, my lord, the trial court, having regard all the materials, comes to this conclusion, my lord. It cannot be said that it is illegal or perverse, my lords. Now, all arguments are advanced making a defense, my lords. The defense is required to be tried. Now, cross-examination is going on. If she cooperates, appears at least 1 or 2 days, family court, cross-examination, my lords, of either this or the other party, my lords. I respectfully submit it should be for, my lord, 3 hours, 4 hours, or 5 hours at the most total, my lords. Maybe stretching to 1 or 2 days. This, my lords, this is going on. An unfortunate incident, my lords, going on for 2-3 hours every day and for 10 to 15 hearings. Even now they say they are going to cross-examine. Unless this Hon'ble court directs, my lords, that it should be held and she should be present on every day, she will not be present also. Husband would come, advocate would come and again go. And then say for further cross-examination, time is required. It would not be done. It will never be done, despite the Hon'ble court's directed, my lords, because the Hon'ble court would only direct for expeditious disposal because number of other cases are pending. Now the Honorable Family Court is taking up the matter. I'm informed yesterday, again she did not come. And this is a short time. And so they do cross-examination, my lord, for little time, my lords. Then they say one time and go on. And my lord, unless this is controlled, this will never end, my lords. Now the case itself can be over by a month or so if she cooperates with the proceedings. So my finding given that how she has suppressed and now she has actually concocted false records. We may have to initiate action also for creating a family record on and dating it after 4 months of the illicit stamp paper. And this is all to defeat the court order, suppress her. And my lord, she was assistant manager, admitted, and worked in Canada for several years. And assistant manager residing along with the parents. Now they say we have resigned. And we are left the job. And that is very hard to do because all the records of income tax, she has other income, my lords. Everything is borne out from the income tax records. Now, my lord, since it's the fag end, my lords, my humble prayer before the Honorable Court is kindly direct her also to cooperate and finish the case at the earliest, my lords.
My lords, fact is unregistered document is factually incorrect. It's a registered document.
Family agreement.
128. It's a registered document.
Afterwards.
Yes.
Family agreement.
Yes. It's a registered document.
Sir, kindly see now itself, my lords. Right side, stamp paper is of January and stamp paper. And the legal agreement is 13/4/2021. They got a old stamp paper and gets it before the notary and they want to produce this. I don't make any comment on the face of it.
My lords, I have produced, they have not objected for it. Now it's for the first time across the bar is making a submission. One thing, for not cooperating, all those things is not a matter of record. They have not produced any document to show that I am not cooperating as such. Before marriage, I was staying in Canada. I am not disputing it. And after marriage, he has called me that you should leave the job and come back to him.
Is it a case that you both of them lived for 40 days?
Please, my
Yes,
lords.
only 40 days.
Please, my lords.
40 days.
40 days?
They live together.
That's all. And my lords, court has not dealt with the income of the husband at all. Has just put on the burden on the wife. I am not missing on the part of the family court that no burden should not be imposed on the wife. I made best efforts to produce all those. Let the family court redo the whole thing. It is not the case that madam not cooperating.
When is this application filed?
Yes, this application is filed on 2023. Let him pay at least little sum of money. At least
What is the income of the husband?
the court has never dealt with the income of the husband at all. He suppresses, he doesn't produce any material before the family court, nor family court has insisted to produce any documents. Court never has dealt with the income of the husband, nor it has only imposed burden on the wife.
Submission sees, my lord, that he has been cooperating and appearing. My lord,
Here on the
And my lord's
witness,
expenditure is granted.
have to have-
aspect also, my lords.
For effective hearing, only the expenditure is granted by the family.
Please.
If there is an effective hearing, then expenditure has to be borne by the husband.
hearing means you appear and do
No, if-
some business
That's what
is conducted
family
in the
court
court. Otherwise, no.
No, I'm sorry. That's what the family court reads.
Yes, heard, reserved. Next.
Grateful.